Ladies and gentlemen, thank you very much for the opportunity to speak at this conference. And as it was mentioned early by Professor Szilágyi, we have here also our juniors. So today I would like to address a question that is both technical and profoundly constitutional. What happens when domestic law, international law, and European Union law collide? It also concerns these questions posed by Professor before. Who decides and on what constitutional basis? Already at this stage, I would like to stress that this is not merely a technical conflict of laws problem, but a question about how we understand the very nature of modern constitutionalism. This is not an abstract theoretical puzzle. It is a question faced daily by judges, administrators, and even ordinary citizens in whole Europe. Let me begin with a concrete situation. Imagine a judge in Prague, Bratislava, Sofia, Zagreb, Ljubljana. He is confronted with a normative conflict, a national statute, an international treaty, and European Union law. Each claims authority. It is formally binding, which has been adopted through legitimate procedures. And the question he faces is therefore simple to ask, but difficult to answer. Which norm should prevail? This dilemma lies at the very heart of constitutional theory and of the state sovereignty. Today, I will show how 5 European constitutions structure their response to this challenge. The Czech Republic, Slovakia, Slovenia, Croatia, and Bulgaria. My purpose is not to advance a grand theory, rather I aim to present the basic positive constitutional law and to situate it within the broader doctrinal debate. Let me emphasize from the outset that what I'm presenting today is only a small fragment of much broader analysis, which will appear in a chapter devoted to my research findings and will cover selected states of Central and Eastern Europe. My argument uploads 3 steps. First, I will briefly recall the classical theoretical frameworks used to conceptualize the relationship between legal orders. It is especially for our juniors. Second, I will show the basis constitutional solutions in the selected states. And finally, I will draw some broader systemic conclusions about what this tells us about modern constitutionalism. And this structure will allow us to move from theory through constitutional norms to general systemic insights. For most of this 20th century, the debate was framed by 2 models, monism and dualism. With European integration, another concept, many concepts emerge, especially constitutional pluralism. These frameworks are not neutral. They embody different conceptions of sovereignty, legal authority, and normativity. They therefore shape how we understand what a constitution is and what it does. Importantly, these models are not merely descriptive, they directly influence how constitutional courts argue and justify their decisions. The classical dualist position is associated with Heinrich Triebel. In this model, international law and domestic law constitute 2 autonomous systems. They derive their validity from different sources and regulate different social relations. As a result, treaties cannot operate directly within the domestic legal order. They require transformation through national legislation. This model reflects a strong conception of parliamentary sovereignty. In a deeper sense, dualism expresses a classical Westphalian image of the state as an exclusive source of law for individuals. The monist paradigm is conventionally linked to Hans Kelsen. Kelsen postulated the unity of legal system and a hierarchical structure of norms. International and domestic law form part of one normative order. Consequently, treaties may apply directly and may even prevail over domestic law. This approach is highly systematic, theoretically coherent, and normatively ambitious. And in this sense, monism anticipates later processes of internationalization and constitutionalization of international law. European integration challenged both models. Neither strict monism nor strict dualism could fully explain the reality of the EU. This gave rise to constitutional pluralism associated with scholars such as Neil Walker, Miguel Maduro, or Matthias Kuhn. And pluralism assumes coexistence of legal orders, absence of a single ultimate authority, and conflict resolutions through institutional dialogue. In other words, pluralism attempts to capture a reality which is in which no court can credibly claim a monopoly on the final word. It is best understood as analytical framework and not a prescriptive theory. Before turning to the technical provisions, I would like to highlight the constitutional language of itself. For example, in Czech Constitution, Article 1, Paragraph 2 states the state observes its obligations under international law. Similar provision we can find in Slovak Constitution. Sorry, something click here. The same similar provision we can find in Slovak Constitution. Article 1, Paragraph 2 provides that the state recognizes binding rules of international law. These clauses do not establish hierarchy. They constitutionalize a general attitude, openness, good faith, and loyalty towards international law. They are axiological clauses which give meaning to the more technical provisions that follow. And the Czech Republic constitutional model can be best described as moderate constitutional monism. Article 10 provides that ratified treaties automatically become part of domestic law and prevail over statutes. This is a clear monistic feature. No legislative transformation is required. At the same time, the Constitution itself remains supreme. And the Constitutional Court has consistently emphasized the existence of material substantive core that cannot be overridden. We therefore do not have here pure Kelsenian monism, but rather a control openness. International law is integrated, yet constitutionally framed and guarded. In Slovakia, Slovakia represents perhaps the example of explicit constitutional monism. Article 7, paragraph 2 openly states that EU law takes precedence over national statutes. And in addition, Article 7, paragraph 5 grants primacy to the selected international treaties, especially in the field of human rights. Primacy over the statutes, not over the constitution. Here, the Constitution itself resolves normative conflicts in advance. It does not leave this task to judicial interpretation. Slovakia thus constitutionalizes monism in a direct and unambitious manner. The Slovenian model may be described as monism, and it has democratic safeguards. Article 8 requires domestic law to comply with international law and provides for the direct application of treaties. However, Article 3A introduces parliamentary control over the transfer of sovereign powers. Slovenia therefore combines legal openness with democratic legitimation, and integration is constitutionally permitted but institutionally supervised. In Croatia, in this country, the hierarchical monist model is adopted. Article 140 establishes that ratified treaties form part of domestic law and prevail over statutes, and the normative structure is clear. Constitution at the top, treaties below, statutes farther down. There's no requirement of transformation or no ambiguity about rank. This is a classic constitutional monism construction. And in Bulgaria, follows a general monist model. Article 5, paragraph 4 provides that ratified treaties form part of domestic law and prevail over statutes. There's no special EU clause, but EU law is incorporated through the general mechanism. And constitutional silence on Europe does not mean weak integration, only a different drafting technique. And the underlying model remains monist. Across all 5 states, a common structure emerges. Constitutional supremacy remains, treaties rank above statutes, EU law is constitutionally encoded, and the different concert technique, not direction. The common denominator is constitutional control of integration, not its rejection. We can see here this table with exact articles regulated these things. And free border conclusions follow. First, none of the constitution corresponds fully to monism or dualism. Second, international law is structurally embedded in domestic systems. And third, EU law enjoys explicit constitutional status. Constitutions today function as nodes in a network of legal orders. And finally, let me return once more to the judge with whom I began. He is not only confronted with European Union law, he stands at the crossroads over 3 legal orders: domestic law, international law, EU law. Each claims authority, each is formally binding, each rests on a different source of legitimacy. And this is not the technical problem of hierarchy, it's a constitutional dilemma. Let us begin with international law. Modern constitutions increasingly open themselves to treaties, international courts, and global regulatory regimes. This openness is often celebrated as progress, but we must recognize its structural consequences. International law today no longer merely coordinates states. It increasingly governs them. Human rights regimes, investments, arbitration, environmental obligations shape domestic legislation, constrain political choice, and sometimes override parliamentary will. The state no longer decides whether to comply but merely how to implement. This marks a profound shift from sovereignty as authorship to sovereignty as compliance. International institutions are not elected, are weakly accountable and operate far from national public. And yet their decisions bind parliaments, structure budgets, and influence social policy. This creates a democratic asymmetry, authority without proximity, power without political responsibility. The classical constitutional question therefore returns: who governs and whose name? European Union law represents an intensified version of the same logic. Here we encounter direct effect, primacy, and autonomous interpretation by the Court of Justice. What is exceptional is not integration itself, but its constitutional depth. EU law penetrates the domestic legal system, shapes constitutional balances, and limits national constitutional identity. What began as economic integration has become structural governance. And when international law and EU law operate simultaneously, their effects accumulate. Step by step, national legislation is constrained, political discretion narrows, and constitutional autonomy thins out. This is not a conspiracy. This is a structural dynamic, and the state is not overruled. It is gradually displaced, formally sovereign, substantively limited. In this process, courts became key actors. National judges apply international treaties, follow EU jurisprudence, and mediate normative conflicts. But meditation can turn into submission, because we said here about the dialogue, but in the dialogue, the both parties should be equal, not in hierarchy. In my opinion, now it is something different. In international obligations are treated as unquestionable. If EU primacy is absolutized, then constitutional courts risk losing their core function to protect the constitution as a political community's self-decision. This is why constitutions matter more than ever. They must frame openness, control transfers of power, and define red lines. Identity clauses, constitutional review of treaties, ultra-vires control are not nationalist gestures. They are constitutional self-defense. They express a simple idea: openness must remain revisable. And let me therefore conclude with a balanced statement. International and EU law strengthened cooperation, but they also weaken constitutional self-government. This tension cannot be eliminated. It can be only managed, and it can be managed only if constitution remains supreme, parliaments retain control, and courts remain independent guardians. Otherwise, we risk a paradox. We preserve the forms of sovereignty while its substance quietly evaporates. Thank you very much.